Nowadays, people are more into selling on Amazon but with no or less knowledge about the e-commerce and Amazon law. Before stepping into e-commerce trading, you need to know about certain legal aspects to avoid future litigation that are not only time consuming but costly. In order to avoid such discrepancies, you should be well aware of all the legal aspects of Amazon trading and Amazon selling. Today, we will discuss one of the most important topics in the field of e-commerce, that is Lanham Act. Yes, Lanham Act, which is also known as Trademark Act, deals with the trademark infringement, service mark infringement, trademark dilution and false advertising. Claims for Lanham Act violations are extremely prevalent in relation to the Amazon platform. There are two common situations that arise involving Amazon and the Lanham Act. Number one, when a manufacturer sues Amazon directly or an Amazon seller for a listing that used a trademark without the permission of the manufacturer. And number two, when a manufacturer sues Amazon or an Amazon seller for selling items that are inauthentic or counterfeit and thus violate the Lanham Act for trademark infringement. So in recent litigation, it has been held that Amazon cannot be held liable for infringement when other companies sell infringing products on the Amazon platform. The court in Milo case held, Milo and Gabby LLC versus Amazon, held that Amazon could not be held liable when a third party sold infringing goods on the Amazon platform because Amazon itself did not directly offer to sell infringing goods or engage in any other infringing acts. So what is the difference between infringement and dilution? You must understand this. A trademark is a word, phrase, symbol and design that identifies and distinguishes the source of goods of one party from those of others. A service mark is essentially the same thing as a trademark, except a service mark identifies and distinguishes the source of a service rather than goods. Trademark dilution is a trademark law concept giving the owner of a famous trademark standing to the forbid others from using that mark in a way that would lessen its uniqueness. In most cases, trademark dilution involves an unauthorized use of an other's trademark on products that do not compete with and have little connection with those of the trademark owner. In USA, Lanham Act provides details about the registration procedure of trademark so that a person who is entitled to the protection is likely to face trademark infringement. If any infringement is confronted by the legal owner of the trademark, then Lanham Act is well conversant with the remedies and recoveries of such trademarks. So trademark dilution is concept which means that the use of trademark gradual whittling away or dispersion of the identity and hold upon the public mind of the mark or name by its use upon non-competing goods. So under the Amazon intellectual property policy for sellers, trademarks are often displayed on Amazon's product detail page in the form of product and brand name listed on a product detail page. For example, a trademark appears in the brand name or byline portion of the product detail page shown. The trademark also appears in the product name portion of the product detail page. So this policy provides an overview of intellectual property rights and some common intellectual property concerns that might arise when selling on Amazon. When you sell on Amazon, you must comply with all the federal, state and local laws and Amazon policies applicable to your products and product listings. So you may not violate the IP rights of brands or other rights owners. So violating this policy may result in loss of selling privileges or other legal consequences. However, there are 3 exceptions to this rule. A seller can use someone else's trademark in the following circumstances. Number 1, when selling authentic goods, a seller may use a trademark name to list those goods. For example, a seller who lists an authentic Pinzon product is not necessarily infringing on the owner of the Pinzon trademark because the seller is using the trademark to identify an authentic product. Number 2, when using a trademark word in its ordinary dictionary meaning. And number 3, when making truthful statement that a product is compatible with a trademark product. For example, if you offer a cable that is compatible with the Kindle e-reader, you can use the brand name Kindle to indicate that compatibility in the text of your detail page. You cannot use a logo to indicate compatibility, only the brand name. Any statement you make about compatibility must be true. Thank you very much for watching this video. Follow us on our Facebook and social media pages to watch more videos like this.